Good evening. Welcome, everyone. Welcome. I am, of course, Christian McCray Stewart, the founding attorney of McCray Stewart and Associates, your trusted advocates for justice and peace of mind. Welcome to another live session of Wise Counsel Wednesday. As we all are joining on, let us go ahead and like it. Let's share it. Let's invite some people. And so just as I'm asking you all to like and share and all those different things, I'm going to take a few seconds to do that as well as people are joining on to the live. But go ahead and share it. We have a great discussion for this evening, which I think is always great discussions, right? Because we'll ask you all, what do you have questions about? And we bring the answers. And so it's going to be a great discussion this evening. But let us make sure that we are sharing, we're tagging people, and we are inviting them to come and join us on the live this evening. And as we are doing that, I hope that everyone has had an amazing day today. It's Wednesday, hump day. I mean, we're closer to the weekend. And Lord, we thank you for that. But I really hope that you all have been having not only a wonderful Wednesday, but that your week so far has been very, very good. All right. I did my part, and I hope as everybody is joining on, you are doing yours as well. Good evening, everyone. So, as we stated, another session of Wise Counsel Wednesday. A great discussion for us this evening. Healthcare directives and living wills. Healthcare directives and living wills. This is going to be a good discussion. It's one that is needed. It's one that we definitely need to be mindful of. And I think it's going to be insightful and helpful for a lot of us to bring some things to our mind that sometimes we may not even think about, right? And in some situations, sometimes it's like, look, if it's not happening, we really don't think about it. We really don't address it. But these are conversations that we have to have. Also, as you may see, there is the banner that is going along at the bottom of the video. If you are not already following us on our social media platforms, Instagram, Facebook, LinkedIn, YouTube, go ahead and follow us because we're always sharing information about events and things that are taking place. I'll have some announcements for everyone later on in the live about some of the events that we have coming up that you can get registered for, that you can be on the lookout for to help you with future matters. But make sure that you're following us, all right? So that way you don't miss out on any of the information that you may need. With that being said, for those of you who may be new, first we want to welcome you on to the live. And what we do, this is a live Q&A. So you come and you bring your legal questions for the topic that we have for that evening, and we're going to answer them. Disclaimer, these answers do not formulate an attorney-client relationship, right? We're trying to provide general guidance, general insight that's going to be helpful for you in making some decisions and determinations about what you need to do moving forward. Now, should you need to have an in-depth consult, you can find us on all our social media platforms. We'll have some information for you available at the end as well, but this is the perfect time to ask those questions. So you can place them in the chat. You don't have to delay. At any point in time a question comes to mind, throw it in the chat. We already have some that have come in, so I'll be reading the question and answering them. So the information is available to everyone, of course. But don't hesitate. At any point in time you have a question, make sure you just drop it in there. And so without further ado, we are going to go ahead and jump into our live Q&A. And as you all are joining on, welcome. Definitely a pleasure to have you on. We're glad everybody's able to come on. And just make sure that you're sharing as you come on. All right. So as we start this off, one question that we had, and I think this is probably the question we need to actually begin it. It gives everybody some insight and guidance into the topic that we're actually discussing, right? This is a arm or a branch, if you will, of estate planning. But one of the questions we got is, what is a healthcare directive and how is it different from a living will? Wonderful, wonderful question. So when you think about a healthcare directive, you can think about a pot that's full of everything that you need, right? Or a toolbox. In your toolbox, you have all the tools, right? But within that toolbox, there may be a specific tool, a screwdriver, a wrench, or something that you utilize for some specific job. Well, your healthcare directive is kind of like that toolbox. It has everything that you need related to medical treatment, medical power of attorneys, end of life treatment, things of that nature. And the living will deals specifically with end of life matters. So your living will is kind of inside of your healthcare directive, if you will. It's inside of your toolbox. And I know as I kind of describe this more, we may touch on some of the other questions that we have. So for instance, a living will, you get to the place where you're informing individuals, your doctors, you're informing your loved ones, what you want to happen when you are nearing the end, right? When you're nearing end, when it comes toward end of life, a lot of people look at it in the perspective of if you're having a terminal illness and what do you need? You're able to provide insight on whether or not you want life-saving measures. Like some people have DNRs, which are referred to do not resuscitate. Some people don't want those things to happen. Some people, it's like, look, give me all the measures that's needed to keep me alive. Some people may say, hey, look, if I'm in a coma for a certain amount of time, look, if I can't survive off, without being hooked up to machines, then I don't want to be hooked up to machines. And so this is why this conversation is so important, because you don't want to, 9 times out of 10, we know. Good evening, my dear mother. So glad that you're able to join us. And good evening, everybody, as you're logging on as well, if I happen to miss anyone. And don't forget, as we're joining on, go ahead and like and share. You all know about the algorithm. Let us make sure we're pushing this information out to everybody. Because I will say this, even though we practice in Mississippi, Texas, and Georgia, when we're providing this general information, it will help people, even if they're not in the states where we practice, all right? So back to this point, all of us may have some type of insight into how we want things to happen, how we want to leave. If we're in a state where we can't make those decisions on our own, if we could, what do we want? Also, it prevents you having disputes between loved ones in regards to type of treatment, prolonging health, things of that nature. And I will tell always, I come to you all and I share life experience with you, because sometimes it's just make it real, right? Let this hit home, because this is important. I want everybody, the takeaway from today is, if you haven't considered these things in regards to your healthcare directive, which includes like your medical power of attorney, information that you want your doctors to know, your living will, be thinking about these things. Start writing it down so that you can get this in place. But you have a situation that, say you're at a state that you can't make decisions on your own, right? Where they're determined that you're not mentally competent, or you could be at a place that you have dementia. You can have these things in place to where what you want is laid out, and also you have someone who is designated to make the decisions. We had a situation, a case where siblings were feuding. It was just bad blood. And this is something, it happens, right? It happens in families. People just don't get along. They can't come together for any reason at all. And in this instance, they couldn't come together to make the decisions for what was best for one of their parents. And in that situation, you had a third-party guardian who had to come in, right? Someone who doesn't know their parent, who doesn't know them, who doesn't know their history, who doesn't know their religious beliefs, who doesn't know any of these things. And so now that third party is going to be the one who is making the decisions in the best interest of that individual. And this is not to say that third party guardians are not capable, that individuals are not in good hands. Should those instances occur or arise, but this is something that we have control over. You have control over. You can put things in place. You can put things in place so that exactly what you want can be done and you prevent such situations from happening. All right, so let's see. What specific elements should I include in my living will or advanced healthcare directive? Okay, so yes. So now let us jump into the nitty gritty of it all. So, and I kind of touched on it a little bit, right? In regards to like what they are and what you're trying to do. And I'm also looking, so when I see questions that also come in the chat, I'm comparing them to what comes in already. So that way I'm kind of make sure that I'm tracking and I'm addressing everybody's question, right? Okay. So so in these documents, some things that you're talking about. Do you want life-sustaining treatment? Right? Do you want to be on feeding tubes? Do you want to be on life support if you're at a state that you need the machines to breathe on your behalf because you can't? Pain management. Some people's preferences, whether it's because of religious reasons, spiritual reasons, what they may and may not do is important. It's specifically blood transfusions. Some people, for their based on their religious backgrounds, they do not want blood transfusions. So this is something that you can place in this document to let doctors know, right? That is a huge, and that's one that I've seen. And so what happens is that if it's not, 9 times out of 10, doctors have a medical, not 9 times out of 10, they have a medical standard that they're supposed to oblige by, right? That they function under, that they practice under. And so they're trying to do what's in the best interest. They're trying to do what's needed to make sure that you're surviving, make sure that you're getting healthy, all those different things. But some people have a preference to say, look, okay, the DNR that we discussed, do not resuscitate. I do not want you to, if I flatline, I don't want you to resuscitate me. Also, organ and tissue donation. Yes, some of us probably have documented this when it comes down to our driver's license. I know, for instance, Mississippi, we have it on our license. Texas, I think it's on there as well. But this is something that you can put in your advanced health directive. This is something that you can put inside of your living will. Another thing, and I kind of touched on this briefly here when I was discussing about this one case that we have, is the appointment of someone. It's like a medical power of attorney, right? And the medical power of attorney is basically listing out who is the person to make that decision, right? I spoke at a conference some time ago, and I was saying, hey, you have some people, you're like, look, I don't want this person to make these decisions for me. And I said a little tongue in cheek, but I think we do, if we're just being real, right? Talking about life. We have some individuals who are just like, I do not want this person to be the one who has to make these decisions about my care, about my treatment. Be mindful of that. You have some parents, they may prefer one child over another for various different reasons. And sometimes it's not necessarily in a negative aspect. It's just someone that you trust with your life, right? And it doesn't necessarily have to be. So, of course, if you're married, will it be your spouse? Possibly. If you have children, could it be your children? But it could be your best friend. You can choose any person that you like to be the person who's going to be in that role of making those decisions for you. But you're able to appoint an individual who could do those things. Okay. All right. So we also have here, why is it important to have a healthcare directive in place, even if you're young and healthy? Wonderful, wonderful question. I actually just had this conversation with my team. And So even if you're, so some people, like I say, we have these situations. It's just like, look, if it hasn't become an issue, it's something that I don't have to worry about. So even if you're young, for our young people on here, and for the young people who may come back and you may see this, or even for parents and you have children who are going out to college. Well, once you turn 18, parents don't have the legal right to access to your medical information. If something happens to you, the hoops that sometimes they have to jump through to get information, to advocate for you, to be the voice that's heard when it comes down to treatment, it could be difficult, right? And so by having these things in place, your health care directive, your living will, and you having your parents in this situation, you could have them appointed as the individual who is making these decisions for you. They're able to act on your behalf. Things happen every day. There's car accidents. I mean, even here recently, within the last few years, you heard about young people who were, passing out for various reasons, heart issues. The thing about it is, and I will say this, tomorrow isn't promised to any of us. The next minute isn't promised to any of us. We never know what can happen, because the thing about it, on the outside, everything can look totally fine. In the inside, anything could be going on. If you're in a place where you're in a coma, you're in a place where you can't advocate for yourself, you can't speak for yourself, and it's determined that you can't make those decisions, you want to have people who know your wishes. You want to have people who care about you making those decisions. You don't want to have it where there's decisions that need to be made immediately and there's delays taking place because they don't have these things, or there's kind of this back and forth, right? You see these situations. I'll share a scenario. So you may have a situation, you have some people who are in what the state recognizes as common law marriage. So many different issues that can come up with that. I'll focus on this for the scenario just because of an experience in a case. You have common law marriage, and so you have this spouse who's trying to advocate and speak on behalf of their spouse in regards to, this is what they want, this is what should happen. No, leave them on life support, take them off life support. And then you have this individual's mother or parents who are saying otherwise. You find yourself in a conundrum there because, okay, do you have the proof that's necessary at that point in time to prove common law marriage and that you are the person to be authorized to make those decisions? Or is it going to be the parents who are going to have that decision-making power? And so in this instance, if we are taking the time to prepare ahead of time, we would have these documents in place. And the thing is when you have these, I know I'm going into another question. When you have these documents, when you appoint somebody who's going to be your guardian per se, the person who's making these decisions on your behalf, you can make sure that they have a copy of these documents. You can also make sure that they are filed with your healthcare provider. You can also, keep copies in your home, but you want to make sure that the people who need to have this information, it is available to them. So is a living will the same as a DNR? Which one is better? So in regards to whether a person does not want to receive, does not want resuscitation, it can be included in the living will, but the living will has much more in regards to it. Like we were saying, look, do not resuscitate, or do not, I don't want to be on life support. If I'm in a coma, this is what I need, or, things of that nature. So it's included. It's not simply, it's not the same as a DNR, but it does address that aspect of it. And I would say that it's not like one is better than the other. Typically, I know when we are addressing living wills, I do it now in my personal practice. When I was in the military, we did it as well. This was something we made sure that we addressed. And so when people came and got their healthcare directives, the whole package, if you will, we made sure all those issues were addressed. We asked them questions in regard to all of those things. So that way it covered everything. More, especially in these situations, I would say more is always better, more is always better. And so understand, so and two, so the living will is not necessarily the things that you don't want, it's also the things that you may want, right? And so it's you having the opportunity to truly advocate for yourself now, should you find yourself in a position that you can't advocate for yourself, right? And I do want to address the point because some people have DNRs and they don't have a living will. Some people have DNRs and they don't have medical powers of attorneys. So people can have those documents or that DNR stand alone. However, my recommendation, if someone comes to me, I'm going to say, look, you want to address all of this now. Now, by all means, that decision is strictly going to be up to that particular individual, right? But my recommendation would be to address all of it. Don't just do a DNR and, you know, make the decision not to do the rest of them, right? Because there's other things that are important to you. There's other things that are important to individuals that I would think that they want to cover. Life happens, coma, stroke, as I mentioned, dementia, all these different things, all these different things. To see a family member going through dementia and they're forgetful and they don't know different things, well, you're able to come in and assist them and help them to navigate that season of life should they find themselves in that situation. You could have someone who goes to surgery and say something doesn't, they're under anesthesia, right? You go to have a surgery, you're under anesthesia, something comes up, they need to make a decision. Well, guess what? You can't make the decision. You don't even know what's going on. But if you have that person, whether it's your spouse, your parent, your best friend, whoever is the acting person for you in that situation, they're able to go and consult them to find out what decision needs to be made. And so if you've already set out, this is what I want or what I don't want when it comes to surgery, treatment, all these different things, that individual is able to advocate for you. Good evening, First Lady. How are you? Thank you so much for joining on. And just for anybody who's coming on, we're discussing healthcare directives and living wills and just what they are, various questions that people have submitted to give some insight. This is definitely an area that people need to be mindful of. If you do not have these documents in place, if you do not have this toolbox set up, it is one that you should be mindful of thinking about and looking to have those conversations and get these things done. Are there common misunderstandings about living wills or advanced healthcare directives that I should be aware of? Common misunderstandings. So for the most part, the documents themselves are straightforward. And one thing that I would say is I tell people, you make sure the necessary people need these documents, will have these documents, right? Because the thing is, decisions are made in conjunction with those, not outside it. So some people think that, oh, well, you know, if they don't have if they do have the documents, people can still make any decisions that they want on their behalf. And no, that's why I made a statement to say, look, make sure that your physician has a copy of this. Make sure you can provide various copies to various individuals to ensure that your wishes are going to be followed. What you desire is going to be followed. But over the time that I have been doing this, and not to say and trust, that's why we're talking about generally, right? I have yet to see a situation where a person's healthcare directive and living will hasn't been followed. Typically, what I see when you see a lot of issues, a lot of back and forth, a lot of confrontation, a lot of disagreements, is when people do not have these things in place. Yes. So the question is, do you recommend that once we have a living will or advanced healthcare directive, we go ahead and provide it to our primary physician or upload it to our healthcare chart. Yes, 100%. You definitely want to make sure that you go ahead and provide that document to your healthcare physician. Any people that you may be seeing for treatment, right? As we get older, some people have different ailments, different illnesses, different things, various people that they're seeing for various reasons. But definitely make sure your primary has it. And if there's anybody else that you're treating with for whatever reason, you make sure that they have those as well. And if you have a health chart, then you make sure that gets uploaded there. Because you want to make sure you have a voice in situations where you're not able actually to voice that opinion. All right. So let's see. The next question that we have. Oh, and I kind of touched on this, but it says, what happens if I don't have a healthcare directive or living will? Other people are basically making the decision for you. Um, if, of course, they don't have loved ones or next of kin, and they're not able to determine your wishes and things of that nature, or touch bases with family, then, of course, the health providers are going to do what's in the best interest to keep you alive, to treat whatever injury or illness that you may have. Is it hard to revoke or change my directive if my wishes changes? No, it's not hard at all. But what I would say is that, so should a time come, and say at some point in time you're like, look, I do not want, I know we've been saying the DNR, do not resuscitate. That's just an easy one, right? So initially when you draft, it's like, look, I have a DNR. I got a DNR. Do not resuscitate. But after some time, you think about it. You're like, well, no, I do think, if for whatever reason, I do want them to try. You can go back and you can change that. Of course, if anybody you provided those documents to, you want to retrieve those, ask them to destroy it, and then you want to provide the updated version of your documents, so that way your current wishes will be what's in place. And so you can go and get your documents changed or updated. It's not something that takes an excessive amount of time. And in most jurisdictions, your healthcare directives, we typically recommend that you have witnesses, but you don't have to. Some you can do them, and then long as you have it notarized, you are good. You are good to go. Okay. Medical power of attorney and the healthcare directive. Okay. So basically, the healthcare directive, as mentioned, is kind of like your toolbox. It has everything in there related to, medical treatment, health, all those different things. Now, what happens is, so in there, you're letting your doctors know, you're letting people know, this is what I want to happen. If I find myself in a situation where, I'm ill, I'm injured, and I can't make decisions, this is what I want to happen. Now, you could have a individual who is, you have an individual who is able to make those decisions for you. Okay. And so that's what the medical power of attorney does. So let me say this. If you had a general power of attorney, this person could make decisions for you in regards to signing documents and things on your behalf. And in those situations, you can even give them a power to make financial decisions. So if you had a situation where, say you wanted to close on a house, let me do it this way. I like to try to break it down so everybody kind of understands it. So say if you had a financial power of attorney, you were going to be traveling, you're trying to close on a house, you gave somebody the power of attorney to execute those documents. They will be able to go in your place and sign up on those and do the closing. Now, when it comes down to the medical aspect of it, you're in a place that you're injured, right? And let's give the example of a blood transfusion. You're losing blood, and the only way that they're going to be able to assist you is to do a transfusion. but you stated that you do not want to do transfusion based on your religious beliefs. And so what happens is you have that person who's telling them, no, you cannot make those, you can't do that. We're declining that. It's just as if you went in there for treatment and they ask you now, say they're having different vaccinations that they're providing. You say, no, I don't want to take the flu vaccine. I've never taken the flu vaccine, and so I don't want one now. Well, rather than you being able to speak on your behalf, someone else is doing that for you. You also see this come into play. And what I will tell you too, I kind of touched on this earlier as well. An example of it is it prevents the need for a guardian, right? You see a lot of elderly people find themselves in situations that if their health begins to decline and there's treatment and things that's needed for them, that if they don't have family members to assist them, or the family members can agree, a guardian is appointed. And that's somebody who's able to make decisions on their behalf, what's in their best interest in regards to treatment, facilities, and things of that nature. And so I hope that cleared up, kind of, provided some additional clarity about healthcare directive all over in general, and then a medical power of attorney. Who should you choose as your healthcare proxy or agent, and what qualities should they have? Choose a person that you trust. Choose someone who you can have the conversations with. So think about this. You choose someone who's going to respect your wishes. When we typically find ourselves in these situations, no one really wants to let their loved ones go, right? Sometimes, so say for instance, you're I don't want to be on life support. And you go and the doctors are telling them, life support could help, life support could extend, all these different things. You want someone who's going to be strong enough and capable to carry out your decisions, right? So if you're saying that you don't want life support, and even though that's what doctors are trying to do, even though that's what's going to keep you around, you have someone in positions who's going to say, well, look, I know this is what he or she wanted, and so I'm going to respect those wishes, regardless of how hard it may be for them to actually do so. Good evening, Miss Laverne. Okay, so we answered that. We touched on that when someone else was asking about being able to change their healthcare directive or living will. Okay, and someone is asking, and we've kind of just intertwined this a little bit. How can your faith or values be reflected in your healthcare directive? Whatever you believe. If there's a certain type of treatment that you don't want to have, if there's a certain type of um vaccinations and medications that you don't take for religious reasons, you're able to set those things out in regards to what you will receive and what you will not receive. And if it has a religious basis or a faith basis, that's totally fine. But this is while we're having this conversation, for people to be knowledgeable about it, right? To come and answer these questions for individuals, because some people don't know. And the thing is, they don't know because we're not having the discussions. And so you are able to, everything about you is encompassed and covered in these documents, right? Because your faith makes you who you are spiritually. What you believe is a part of who you are. And so in making these decisions, the thing about it is you'll sit down with your attorney. If you contact us, you say, hey, I need to, and like I told you, it's a part of the estate planning. So we have these discussions and tell people, hey, you need to get your healthcare directive, your power of attorney, your medical power of attorney, living will, and all these different things. And you fill out a questionnaire, and it's asking you all of these questions. So that way you're ensuring that all these things are addressed. You're assuring that you're covering all this, and it begins to make you think about it, right? And sometimes that's all it takes. It's just a little time to actually sit down and begin to think and say, hey, you know, if I'm in a worst case scenario, what does this look like for me? What does it look like for my family? And I'm glad I mentioned that because this is kind of, we can go right into this next question. How should families approach difficult conversations about end of life care? I would say I don't necessarily think there's an easy or hard way to jump into the conversation. You just begin to discuss it. Like, and I think even when we talk about just like wills and estate plan in general, sometimes people have this thoughts like, oh, if I talk about it, then that must mean that something's going to happen, or I'm thinking that something's going to happen. No, it's just called that you're being prepared. You're being responsible. You're taking the initiative to ensure that things are in place. And what I will say with these set of documents per se is once you have them, unless it's a situation where we had the question earlier, if your change, your belief changes, your wishes changes. Beyond that, once you have these, they're set in stone. You don't even, it's not something that you have to continue to go over and over. Okay. But you just have the discussion. Hey, you know, if X, Y, and Z happened, what would you want? If you're in this situation, what type of treatment do you want? What type of life sustaining measures do you want them to extend or not extend? Do you want to be resuscitated? I mean, and even in some of these too, you have some people you can or cannot. They discuss like, how they want to when it comes down to potential funeral arrangements. If they get to that point, some people have these in there, and sometimes it's like a separate document, but it's just to have the conversation, and you'll be surprised of the insight that you get. And the thing about it too, it helps makes decisions easier down the road, right? If you have a loved one who is on life support, if they told you, look, I only want to be on for this long. If my health doesn't improve, I want to be taken off. Now, you don't feel as though you're the one who had to make that decision. They were able to express their wishes and you just obliged. And so that a lot of these things, when we're thinking about it, we are assisting our loved ones, because ultimately when we get in those places, let's just be honest, if we find ourselves in those situations, it is typically our loved ones who are making these decisions. It is typically our loved ones who are having to bear the brunt of that. And we can assist them by saying, look, this is not even something that you have to think about. I already have it down in black and white. If we find ourselves in this particular situation, this is what I want to happen. Oh, I really, really like this question. What are the considerations for parents of minor children when drafting healthcare directives? And so remember when I said that this is a part of like your overall estate planning, right? When you're doing estate planning, you have minor children. One thing that we're going to ensure that we are telling you about is that you want to set up where you have a guardian for your children. So if you find yourself in a place where you're incapacitated, you're in a coma, you're injured, and you can't see to the daily needs of your children, you want to have somebody who's going to be able to step into place. And whether that's temporary or it's permanent, you want to do that. And so we break it down, of course, when we do our live Q&As. We're breaking it down because in all the various areas of law, you can get very detailed about specific things. So we pulled out healthcare directives and living wills in general to have this discussion tonight. But what happens when you're doing your overall estate planning, it's going to be conversations with you saying, hey, do you have minor children? If you have minor children, if you found yourself in a situation where those children needed to be taken care of, who do you want to place as guardian, right? And so that's how that's going to be addressed. Oh, this is a great question. Can your healthcare directive cover mental health decisions or only physical health? It can cover the mental health decisions. Anything related to health in general, it can cover. It can cover. Um, and I would say that it's needed. It's needed. I'm always careful when I share stories because, of course, certain things we're always protecting privilege, right? We're not disclosing people's information. We're definitely never will disclose names. But sometimes in some of these questions, it begins to help me relate back to different cases that we've seen. And what I will say is that even when it comes to mental, you may think, oh, well, I will never be in a place where I need to have somebody to assist me in making mental health decisions. You never know what life will throw at you. You never know what you will encounter. And I would say this, especially for those of us who have minor children, let us be mindful that you could at any point in time you could potentially find yourself in a state where you're not your best self. And if you are not your best self to make decisions on your behalf, then obviously you're not in the best state to be able to make decisions for your children. Find individuals that you can trust and make sure that you have these things in place. And so some key points as we're kind of I'm looking here to make sure I didn't miss any of the questions. And very good questions. And like I say, this is one that for the most part is very, let me be careful. I guess from my point of view, it's very straightforward. But what it encompasses and what it's about. The main thing is you are deciding what you want. You know what you want. You've given it thought. And when a time comes, this is what I want to happen. Should I find myself in a worst case scenario? I'm in a car accident, I'm injured, I can't make decisions on my own. This is what I want to happen. This is the treatments that I prefer. This is what I don't want to happen. You're able to set those things in place. Second, you don't leave that to your loved ones to make hard decisions, right? Um, I've experienced that like personally. And it's just one of those things that if your wishes are already set in stone, it's already been communicated, people already know it. It's truly it helps. Not that it makes it any easier that anything of that, but it truly does help. It helps to say, look, I know this is what this individual wanted, and then I'm going to respect their wishes. Okay. And as we always say, from state to state, it's truly going to vary. But the gist of these, when it comes down to, what these documents are, what they allow you to do, what they equip you to do, what they put in place for you, is for the most part overall the same. When it comes down to the the technicalities about how they need to be formatted, whether you need witnesses, a notary, all those different things, those things are something that your attorney can assist you with navigating. In my opinion, that's not the utmost important. The utmost important is to go ahead and have these conversations so that you're able to ascertain what you want and you're able to go ahead and get them in place. Okay. Um, if anybody is having some final questions, I mean, please go ahead and put those in the chat. I will go ahead and share. So if this is something that you need to get in place, you don't have your healthcare directives, you don't have a living will, just in general, you don't even have your estate planning documents. When we're talking about, your will and all those different things, scan the QR code, schedule a consult with us. Let us begin to have a conversation with you to help you. As we say, McCray Stewart and Associates, we are your trusted advocates for justice and peace of mind. This is that peace of mind aspect that everything is set in place for you to be able to live life and know that your family is going to be okay. Your family knows what your final wishes is. Your family doesn't have to make some of those hard decisions that are needed. Okay. How often should I update these documents? Yes. And so with this one, unless for some reason your wishes change, typically when individuals or the person who you are appointing, the person you're going to appoint to make these decisions on your behalf, something happens there. Once you kind of get these documents in place, as far as a healthcare directive and your living will, you really don't have to go back and change those. Like, I'll use myself as an example. If I do my documents right now, well, I know my husband is going to be the person who is my medical power of attorney, right? I know what I want as far as, life sustaining treatments, all those different things. And the likelihood of those things changing is slim to none. So if I did my documents last year and here it is 10 years down the road and I think about it, nope, everything is still the same. I don't want to change anything. 15 years, 20 years, unless I get to a point that my husband and we have reached our golden years, and the Lord calls him home. At that point in time, then I may need to consider, okay, I need to redo, and mainly in this one, just my medical power of attorney, because I need to appoint someone else to make those decisions for me. So that was one thing that was mentioned, like having these conversations and getting these things in place with these for this particular topic that we're referring to. It's probably not one that you're going to have to update often. Unless, like I said, unless there's potentially some change dealing with your power of attorney, the agent that you've appointed. And other than that, unless your wishes and desires change, once you have these documents in place, you'll be good to go. I will add this. So when you're dealing with estate planning, typically the documents that you do see change a little bit more often potentially is the wills and trust. And that's basically the wills because there's been a life-changing event, right? You started off when you first got your will done, you were single. Then you got married. Then you had children, you had a child, you had another child. So things of that nature cause you to change, to update those estate planning documents. But wonderful question. So typically, yes, when it comes down to your healthcare directive and your living will, you're not going to have to change those much. Also, so of course, you can scan that QR code. You can schedule a consultation with us. More than happy to answer questions that you have, for guidance that you need in figuring out what you need to get in place. Also, if you're not following us on social media platforms, go ahead and follow us on Instagram, Facebook, LinkedIn, YouTube. There's always information that we have out there that we're trying to keep you all abreast of. And with that, we are having a legal clinic tomorrow. It's actually taking place tomorrow. We have partnered with Dominion City, Dallas, and we're going to be holding a legal clinic tomorrow. It's a free clinic. Scan a QR code, get signed up between 1:30 and 4:30. It's not a particular area. Whatever your legal issue is, you get signed up, you'll have a meeting, and we'll discuss that and be able to get you on the right path of what you need to do in handling that matter. Also, I have the privilege to be speaking at the Attract Abundance Conference, October 24th through the 26th, 2025. This conference is being held by or hosted by Terry Alford. Amazing woman. And as it says, attract abundance, everything about building wealth, and not only for ourselves, for the future generations. And so all the information that you need is going to be presented at this conference, and not only an opportunity to receive information, but to network and to get connected with some people who are aspiring to obtain and achieve the same things that you desire, right? So we have a discount code. If you want, you get signed up for it. If you use my discount code Christian10, you will get your discount. But if you haven't got signed up for that, make sure that you do. Also, it'll be in our newsletter to kind of keep you all updated. So if you're not signed up for the newsletter, make sure that you get signed up. We only send out one email, one newsletter a month, just to keep you all abreast of information. And what we say, knowledge is power. And we're all about equipping our past, current, and future clients. All right. So with that, it has been a pleasure to come and join you all again for Wise Counsel Wednesday. Remember, you can be shooting us DMs, commenting on the previous lives with your questions that you have for various legal legal areas, so that way we can bring these topics to you and that we can answer your questions. It has been a pleasure. You all come back and make sure that you're sharing and inviting with other people so we can continue to get the news out. We can continue to help people. We continue to equip them. All right. We want to walk alongside you in your various legal journeys so we can pursue the justice and make sure you have the peace of mind that you truly deserve. Good night, everybody.